Good day, everyone. We are the Group 4 of 3M5, and we're going to present a video digest case between the Bank of the Philippine Island and Gregorio C. Rojas, with a GR number 157833. Moving on from the facts of the case, Gregorio C. Rojas, the respondent, sometime in March 1993, delivered stock of vegetable oil to spouses Rodriguez and Marisa Kawili. As for their payment, therefore, spouses Kawili issued a personal check amounting of 348,805.50 cents. However, when the respondent tried to encash the check, it was dishonored by the bank. The spouses assured him that they would replace the bounded check with a cashier check from a BPI, which is the petitioner. What happened next? On March 31, 1993, the respondent, along with Rodrigo Kawili, went to the petitioner's branch in Shaw Boulevard at Mandaluyong City. The branch manager, which is Elma Capistrano, personally attended to them. Upon her instructions, the bank teller, which is Lita Sagon, prepared a BPI cashier check with the number of 14428 with the amount of 348,805.50 cents drawn against the account of Marisa Kawili. Rodrigo Kawili then handed the check to the respondent, with Elma there witnessing it. So for the following day, on April 1, 1993, the respondent returned to Inshaw Boulevard to encash the cashier check, but it was dishonored. Elma informed him that the Marisa account was closed on that date. Despite the respondent's insistence, the bank officer refused to encash the check and even tried to retrieve it from the respondent. The respondent then called his lawyer, who advised him to deposit with the check in another account in a different place at City Trust with Ortigas Avenue branch. However, the check was still dishonored on the grounds account closed. For the regional trial court involvement, on September 23, 1993, the respondent filed with the Regional Trial Court Branch 263 at Pasig City. The filing was a complaint with a sum of money against the petitioner. It was decoded as civil case number 63663. The respondents prayed that the petitioner be ordered to pay the amount of the check, damages, and cost of suit.
So next, for the petitioner's response, the petitioner specifically denied the allegations in the complaint. They claimed that they issued it with good faith and that its dishonor was due to lack of consideration. They also stated that the remedy was not to sue them, but rather to sue Rodrigo Kawili, who purchased the check. As a counterclaim, the petitioner prayed that the respondent be ordered to pay the attorney's fees and expenses of litigation. The petitioner then filed a third-party complaint against spouses Kawili, which were later declared in default for their failure to file their answer. Then, moving on, we have the regional trials court's ruling. So, this was the decision made by RTC. Wherefore, in view of the foregoing premises, this court hereby renders judgment in favor of herein plaintiff and orders of the defendant, Bank of the Philippine Islands, to pay Gregorio C. Rojas. Now, before moving on, when you look into the case on the internet, you will see that there will be a typo with the who with the words to pay Gregorio C. Rojas. It will be wrong, so I just changed that. So moving on. Uh, the bank BPI will pay Gregorio C. Rojas the sum of 348,805 and 50 cents, the face value of the cashier's check, with legal interest thereon, computed from April 1, 1993 until the amount is fully paid. Then the sum of 50,000 for moral damages, the sum of 50,000 as exemplary damages to serve as an example for the public good, the sum of 25,000 for and as attorney's fees, and the cost of suits. As to the third-party complaint, the spouses were ordered to indemnify the defendant such amounts adjudged and actually paid by it to the respondent, including cost of suit. Then we have the Court of Appeals. So on appeal, the Court of Appeals in its decisions affirmed the trial court's judgment. Petitioner ascribes to the Court of Appeals the following errors. 1. In finding that the responder is a holder in due course, and Number two, in holding that the petitioner is liable for the amount of the cashier's check. Moving forward, the Court of Appeals stated also in Section 2 of the Negotiable Instrument Law provides what constitutes a holder in due course. A holder in due course is a holder who has taken the instrument under the following conditions. These are the following conditions: that it is complete and regular upon its face, that he became the holder of it before it was overdue and without notice, and that it had been previously dishonored if such was the fact. Then that he took it in good faith and for value. Then that at the time it was negotiated to him, he had no notice of any infirmity in the instrument or defect in the title of the person. Now, if you were listening in the previous slides, you would see that there are some uh, there are some here that checks of what the respondent was experiencing. So what they said was, as a general rule under the above provision, every holder is presumed prima facie to be a holder in due course. One who claims otherwise has the onus probandi to prove that one or more of the conditions required to constitute a holder in due course are lacking. In this case, petitioner contends that the element of value is not present. Therefore, respondent could not be a holder in due course. Then they also, in section 25, value what constitutes. Value is any consideration sufficient to support a simple contract. An antecedent or pre-existing debt constitutes value and is deemed as such whether the instrument is payable or on demand or at a future time. The court ruled that value, in general terms, may be some right, interest, profit, or benefit to the party who makes the contract, or some forbearance, detriment, loan, responsibility, etc. on the other side. Here, there is no dispute that the respondent received Rodrigo Kawili's cashier check as payment for the former's vegetable oil. The fact that it was Rodrigo who purchased the cashier's check from petitioner will not affect respondent's status as a holder for value since the vegetable oil he sold to the spouses. Verily, the Court of Appeals did not err in concluding the respondent is a holder in due course of the cashier's check. Then, furthermore, it bears emphasis that the disputed check is a cashier's check. The court held that the cashier's check is really the bank's own check and may be treated as a promissory note with the bank as the maker. The check becomes a primary obligation of the bank which issues it and constitutes a written promise to pay upon demand. The court also took judicial notice of the well-known and accepted practice in the business sector that a cashier's check is deemed as cash. This is because the mere issuance of a cashier's check is considered acceptance, therefore. So, for the final ruling, in view of the above pronouncement, petitioner bank became liable to respondent from the moment it issued the cashier's check. Having been accepted by respondent subject to no condition whatsoever, petitioner should have paid the same upon presentment by the former. Wherefore, the petition is denied. The sealed decision of the Court of Appeals, 4th Division in CAGR CV number 67980 is affirmed. Cost against petitioner. And this is the end of our presentation. Thank you for listening.